I'm going to speak about some of the specific legislative updates from 2016, the way the Condominium Property Act and the Common Interest Community Association Act changed. And I'm going to speak about some of the things that are pending in 2017, some that have passed the House, maybe some that have passed the Senate and are still waiting to go to the other chamber. But before we do that, I do think it's important to understand some of the things and some of the influences that are going on out there. And I think both aldermen have spoken to some of these concerns very well. You should know, while it hasn't made much headway this year, but after the city of Chicago worked so hard on the short-term rental ordinance, a bill got introduced in Springfield this year that basically said it would be illegal for any municipalities to be able to have any types of short-term rental ordinances. They wanted to take the power away from the city after they had already done it. Now that bill looks like it's dead right now and not moving, but that didn't just come out of somebody's head. That came again from the industry, the Airbnb industry, approaching state senators and saying, hey, wouldn't it be better if we could just control this on our own? There's a lot of legislation in Springfield that's happening right now that are coming from small groups that are, in my opinion, defining the condominium property industry, defining the roles of management, defining the roles of boards of directors, and trying to say, you folks are all bad. One of the things that I continually pass out to various legislators in Springfield is, here's a survey that CAI, the Community Association Institute, does on an annual basis. And overwhelmingly, year after year, 90% of the people who live in their communities like living there. They like living in their condos. They like living in their homes. They like the way management is. They like the way the board does it. It's that 10%, or in some communities even that smaller percent, those dissidents that are somehow prevailing because they have horror stories. And there are some bad condos out there, and there are some bad boards out there, and there are some bad attorneys and bad management companies as well. And they create the stories, they create the sympathy, and that's what's getting a voice. So when we talk about some of these things, I would encourage you, if you see an email, if you see a blast, if you have a story, if you are a board member, the people in Springfield are tired of listening to me. I'm the association attorney. Yeah, you probably are just saying this because you think it's going to make you more money. Although I'm totally confused as to why they think enacting legislation that allows the recovery of attorney's fees will hurt attorneys practicing in any way. But that seems to be the belief. But the belief is that you folks really don't care about any of this stuff. It's just the management companies and the attorneys that are pushing all of this legislation. So, right, send emails, make phone calls. When your legislators are back in their districts, schedule an appointment, call them on the phone, leave a voicemail with their legislative aide and say, you know what, I looked at this bill, I heard this, I read this. We don't support this, we're against this. They need to hear from board members, from homeowners who actually live there, who will be feeling these effects. Like I said, I mean, they can hear from management, they can hear from me, but they really need to hear from you folks. Okay, so when we talk about some of the stuff that's happening in 2017, it's not final yet. There's still another month to go on some of this. So when you do see these notes, when you see something in the paper, write, communicate with, because there were state representatives on the Gold Coast who voted in favor of 3755.
Really?
Mm-hmm. You can look at the roll call, but there were, and I was surprised because I thought they understood that this bill was going to be harmful to community associations, but apparently not. But let's talk about what has been accomplished. There's a couple of things. I'm going to see if I can use this one instead. Okay. Can everyone still hear me?
Yeah.
This way I can read my notes and not have to balance. So there was some legislation that's pretty important that was enacted in 2016. I'd say the very first thing that we need to talk about is the concept of executive sessions, closed portions of meetings. You should have heard about this already, but if we go back to 2014 and the infamous Palm decision, which everyone thought rocked the condominium world and changed the way we did everything, some of the legislation that has happened since then have been designed to deal with some of the issues. It's not overruling Palm, it's not changing the way, you can't all of a sudden vote outside of the presence of a board meeting, but it really redefined what can happen in a closed session. And I think most importantly, it acknowledged that boards, if they are meeting even outside of a notice meeting, if it's one of these 6 enumerated items, they don't have to send out notice, because it had become a bit of an absurdity that you were going to be discussing something that was a total executive session or a closed meeting discussion, but you had to post notice and the people showed up and said, oh, I'm sorry, this portion of the meeting is totally closed, we're not going to vote on anything tonight. And people scratch their heads and say, why am I here? So now you can discuss these things, but remember, two important phrases: discuss. If you take nothing away from this, this is discuss. Voting still happens at open meetings, but there are discussions that can happen in a closed portion of the meeting, and it's not everything. The very first phone call I got after this passed was, oh, okay, now we can have budget workshops again. No, budget is not one of the items that is included in here. So the items are to discuss litigation, which seems to make sense. One of the other things is to consult with the association's attorney. Again, those seem to make sense. To discuss rule violations. Well, that had always been in the act, and that makes sense as well. To discuss unpaid assessments. Again, common sense. You don't want to be discussing the individual unit owners' accounts in front of the entirety of the membership. Where it really got expanded is the act used to just say to discuss the appointment or employment of an employee. Well, a lot of associations don't have just employees. So that definition was expanded, and it's to discuss the appointment, employment, engagement, dismissal of an independent contractor, an employee, an agent, or a provider of goods and services. So if you want to talk about the person who's, maybe clearing the sidewalks, or the person who's doing the roofing repair work, and it's just a discussion, but we're really satisfied with the way this is going, you can have that discussion. The other nice thing is it allows you to interview the independent contractor, employee, agent, provider of goods and services. So if someone's going to become your vendor, and it's again not a vote, but you want to bring 3 vendors in for a particular issue, and you want to basically allow them to give their presentations to the board, and then at the next board meeting you're going to vote for it in an open session. That can happen privately, rather than again bringing the unit owners in, saying we're not going to vote tonight, and no one's going to ask questions. So I think that's a really important piece of legislation. That was in both the Condominium Property Act and the Common Interest Community Association Act. For people who are part of master associations, I apologize. We missed it in section 18.5, but there is a bill that's been introduced this year, Senate Bill 948, that has passed the Senate and is headed to the House, where we include the exact same language in section 18.5 as it relates to master associations. Another piece of, I believe, important legislation was removal of a couple of words, and that's all we did. So in section 18.4 M of the Condominium Property Act, it describes the board's ability to pledge the assets and secure a loan. Now in some old declarations and some old bylaws, anytime you're pledging the assets of the association, you need the approval of potentially 2/3 of the members. Almost becomes an impossibility for some of the larger communities. They just can't do it. But the balconies need repair, or the roof needs repair, or the exterior has major issues. Well, the board has fiduciary obligation to take care of these issues. Unless they're going to special assess everybody, they might need to go out and borrow money. Those have been imposed upon the association, but there was an opportunity to potentially handcuff the board's ability to do that. Well, we took out the phrase, unless the condominium instruments provide otherwise. Now, the association board of directors and, I can't remember who helped us pass this, but the way he described it was, you've been elected by the membership of the community to make decisions regarding the finances of the community, the repairs, the projects. How can we not entrust you to be able to decide whether or not a loan is a good idea to be able to do this? That's part of your fiduciary obligations. I don't want, Representative Martwick, I'm sorry, I don't want anyone handcuffed not being able to do that, because the alternative is then, okay, well, we can't get a loan, but we can special assess everyone $30,000 a piece. That's not that great of an alternative. Something more of interest and probably something that's going to affect your day-to-day lives. Anyone familiar with the ombudsperson legislation that was enacted a couple of years ago? Okay. There is a big push in Springfield that this ombudsperson language or initial reaction was going to cure the ills of bad condo boards. So there has been an ombudsperson actually appointed in 2017, and I had an opportunity to speak with her 2 weeks ago. And ironically, she said most of the problems are coming from self-managed associations. There are self-managed boards and self-managed homeowners who said, I can't get my board to deal with this. So having professional management is going to solve a lot of the problems that you're experiencing. But the Ombudsperson Act was changed to include a couple of things. Important to associations, there is an internal dispute resolution policy that's in the Ombudsperson Act. And if you heard when it passed, what that's basically is kind of different than your rules and regulations policy. The policy is designed to have homeowners, before they go filing lawsuits, before they go doing anything, make their initial complaint to the board about the actions of the board. Maybe it is something as simple as, I've read the Condominium Property Act, and it says notice of special meetings members must be between 10 and 30 days. And you guys sent this one out 5 days. You didn't do it properly. And maybe if everyone could sit down together and say, yeah, maybe you're right. We missed it. We'll do it right the next time. That policy, I actually think, will be helpful. There are other states who have adopted similar things. It was supposed to be done by the end of 2016. That was pushed back to the beginning of 2019, that you need to have that policy as an association in place. The other significant thing that was done with the Ombudsperson Act is associations do not need to register. The Department of Financial and Professional Regulations kind of thought they were going to be entirely overwhelmed with producing rules, producing forms, or trying to get a mechanism to register every association in the state of Illinois. So they said, can we get rid of that? The Ombudsperson's office by design right now has changed to an educational office. It's an opportunity and a place where unit owners or board members or even anybody involved in community association can seek out or access what's the act, what's the law, where can I look at this, where can I do that? And the website's actually up and it's pretty good. It's got a lot of the relevant statutes so people can access that. And I know the legislators like it because when people call their offices and say, I'm having a problem with my board, what can I do about it? Now this person, the Ombudsperson, is a resource that person can reach out to. So those are a couple of the things that were done relative in 2016. We started 2017 with some comments from other lobbyists saying, you know, you guys accomplished a lot over 2014, 2015, and 2016. Maybe it's time to slow down. So I think when I counted by the end of January, there were something around 36 different pieces of legislation in the House and the Senate that dealt with condominium or common interest communities. Some of them were companion bills, meaning they were same exact language was put in the House and put in the Senate, and they wanted to see which one would make it out, which one would move, or where the changes or amendments would come. But there are some pieces, significant pieces of legislation, as Brian had already talked about, this House Bill 3755. Does anyone know what that is? I feel bad about that, to be honest with you, because I actually feel bad that the organizations that I belong to haven't done enough to communicate to people who are obviously interested and involved in this with this bill. This bill all originates from another case, and anybody who's lawyers will always tell you, you know, bad cases end up making bad law. And this is a bad case. It was a tragic case, actually, between a unit owner who had experienced some terrible leaking in her unit. So she decided to do the thing that I think she got some advice to do, which was stop paying your assessments. Yep. So she stopped paying her assessments. The association, after a year, sued her, and she defended on this action and said, well, I should be able to bring up all these other claims in this action with respect to, you know, what you haven't done. You haven't maintained my property. My home is leaking. I'm getting damage in my property. So, you know, it's reducing the value of my unit. And the court said, yeah, you can file your own lawsuit, but you can't bring that up in the collection case. This is a very specific single issue case. You can't bring it up here. Well, that case went to the Illinois Supreme Court after about a year and a half. I think from what I heard, the attorney's fees incurred on the plaintiff's side of the association in litigating that case was close to $200,000. The attorney's fees incurred by Ms. Carlson, from what I've heard, went around $250,000. So there's this perception as a result of this case that there are abuses going on by homeowner boards, condo boards, against their unit owners. This is one case. Unfortunately, it got the attention of a state representative who is very interested in this. Last year, he attempted to pass he introduced 3 different bills in committee that would basically overturn the Supreme Court case. They didn't make it out of the committee. So this year he went back to the drawing board and he kind of reduced his scope a little bit, and House Bill 3755 came out. Significantly, House Bill 3755 has been contended to be a prevailing party action, and it's gotten sympathetic response because of that. The response is, well, if your bad associations has to be sued because you've done nothing wrong and they've done all of these terrible things to you, you should be able to recover your attorney's fees. And when people hear that, they nod their head and they think, yeah, that seems fair. The association can recover the attorney's fees. Why shouldn't I if I have to fight against my association to get them to do what they were supposed to do? That's not what the bill says, unfortunately. That's the way it's being described, but that's not what it says. It makes any claims or causes of action by and between an association and the unit owner, including when you're suing that person for not paying their assessments, subject to a prevailing party. And that prevailing party is not just a prevailing party, it's this wonderful word that I've never seen used in any legislation before, a substantially prevailing party, a totally undefined term. So in my logic, I would think, well, okay, I know what prevailing party is, that's the winner. Substantially prevailing must be less. So now I'm thinking to myself, okay, we sue somebody who hasn't paid their assessments. Lo and behold, the day of court, they come in, they make all the payments of all the assessments, but they don't pay any of the attorney's fees, they don't pay any of the costs. And they go into court and they say, Judge, I don't know anything, I'm the prevailing party. Not only does the association not get to recover their amounts, I get my attorney's fees as well. Or that rule enforcement case, where they come into compliance with the rule at some point after management sent them a letter, I sent them a letter, I sent them another letter, we had to finally file suit, and we go into court, and lo and behold, they come into compliance, and the judge says, well, you know, the case I'm not going to enter an injunctive relief on behalf of the association because now they're in compliance. Now that unit owner says, oh, guess what, Judge, I won, because they didn't get a judgment. And they certainly don't get to recover any of their attorney's fees. I've tried to communicate to the people in Springfield, you know, these cases, you seem to think that there are boards just sitting there waiting for people to violate their rules so they can file lawsuits. Yeah, we all laugh, right? Yeah. People who serve on their boards and people who've represented communities through management go, I said, this is what happens. Somebody violates a rule. They send them a violation notice. They violate it again. They get another violation notice. They continue to violate it. They get another violation notice. They bring them to a board meeting and they plead with them to stop. They get another violation notice. Then they call me. I send them a letter. They still don't comply. Then I meet with the board and the board says, Pat, what can we do to stop this? And I say, we can file a lawsuit. And the board says, file a lawsuit. It's going to cost us time. It's going to cost us money. We're going to be suing our neighbors. It's absolutely miserable. And I say, this is where we're at, folks. I don't know any other way short of, you know, going there and physically stopping them from doing this. This is why we have courts. This is why we have laws. Like Brian had suggested, you know, sometimes this is why we have rules, and people need to comply with them or change them. There's mechanisms to change the rules. You can get yourself on a board. There's an election every year. So I finally convinced the board to go ahead and file the suit, and the first thing that happens when I walk into that courtroom, the judge looks at me and says, are you kidding me? You're here about an overweight dog. You're here about a balcony that was constructed improperly. You're here about a person who won't put their garbage away. You're here about somebody who's parking wrong. These are the dumbest cases, and they go before the Chancery Judge, and the Chancery Judges in most counties think that they are way above having to deal with something like a dog case. But somehow, the unit owner is the one who's the victim in this situation, and the board's the ones who just can't wait to attack these people. The representative who passed this bill by one vote last week said that the only organizations who wanted to keep this bill from passing were lawyers and management companies, and that this was designed to protect homeowners. I can assure you that there is no legislation that awards attorney's fees and encourages more litigation that isn't supported by lawyers. This will hurt associations. This will hurt homeowners. This will mean next year, if this bill passes, when you reconsider your budget for legal, you should probably increase it. because you're empowering people and you're going to create a cottage industry of lawyers who are looking for these associations who mistakenly screw up, don't send out the notice right, maybe don't have the violation hearing exactly how they're supposed to be sued by their homeowners. And I guarantee you it's not going to result in me having less work as an association lawyer. And I guarantee you it's not going to result in there being less fees. That's what they kept arguing. If this legislation is in place, associations won't sue because they'll be afraid that they'll lose and have to pay the other person's fees. Well, let me remind you of this. If your covenants say that this is a mandatory provision, if you're a board member, you have a fiduciary obligation to enforce the terms of the covenants. And if you don't, you're actually in breach of your fiduciary duty. Or, unfortunately, if you decide to enforce it against one person and not another, it's going to be very difficult to enforce that. So you're compelled with enforcing these covenants, but you're supposed to be fearful of the fact that this rule violator, and what we tried to say is you're protecting the non-compliant unit owner to the detriment of everyone else in the association. And that is not the design of the Condominium Property Act. So that bill has made its way out of the House. It is headed to the Senate. It has not gotten a committee hearing date yet, but it will go through the Judiciary Committee first. There are 11 members of the Judiciary Committee. If any of them happen to be your state senators, write them. Tell them you oppose. It's House Bill 3755. If it gets out of Judiciary, and there's a lot of reasons why bills get out of committee in Springfield. It doesn't mean that the people always support it, but there are 55 senators. If this bill gets voted down in the Senate, it will not be enacted. If it is enacted, it's going to head to the governor's office. That might be another stop where we can fight against it, but I do think it is very important. I guarantee you it is not going to help homeowners. It is going to create a cottage industry of attorneys who want to sue condominium associations, and it's going to increase your budget. And the other thing that I know is going to happen, but since the Condominium Property Act was amended 3 years ago to require insurance companies to cover the cost of defense of non-monetary claims, these claims by the homeowners against the associations, which will include recovery of attorney's fees, you will tender them to your insurance carrier. There will be more and more of them, and then what will happen? The rates go up. Yep. So these claims will all be covered by insurance, and we can all say, whew, okay, well, we'll just tender it to the insurance. Well, you'll pay for it. I guarantee you'll pay for it one way or another. So on that happy note, we can proceed. There actually has been a couple of things. Springfield has been very interesting this year. Like I said, one of the pictures painted is that associations aren't necessarily doing the right thing. So when we're communicating with people, we're trying to talk to them about that we actually are looking out for the homeowners in a lot of these things. And sometimes in looking out for the homeowners, making your board be able to run more efficiently and not have to be bent at the will of the one or two people who are going to complain about everything and argue about everything anyway, benefits homeowners, benefits a majority of the homeowners. There are some changes coming, and some of them will be relevant for management. The Section 19, which is the records request of the Condominium Property Act, it previously was 30 days that the records had to be made available. That is being changed to 10 business days. I highly think that bill will pass that says that. Here's part of the argument, and it's not illogical. There's a lot of provisions in the Condominium Property Act that grant unit owners the opportunity to petition the board to invalidate certain actions of the board, kind of a veto power that the owners have. And those dates were all 14 days. So the concept and the fear was, if I can't get the records as to who all the other owners are and their names and addresses to be able to rally them against this for 30 days, how can I make that petition in 14 days? So it's not illogical. And so some of those dates have changed to 21 days instead, and this has gone to 10 business days. The legislature believed that there was a consistency there. It's going to be ironic because the city of Chicago changed their ordinance from 10 days 4 years ago to 30 days, so it could coincide with the Condominium Property Act, and now they'll be inconsistent with one another again. But yeah, don't wait. A couple other things that are going to be in there, and this one we're really happy about. One of the other big things that came out of the Palm decision is a discussion of what to do with surplus and what to do with deficits. And that's been a big concern because old documents, some of them actually read, you gotta give the money back. I haven't seen that ever happen with anyone actually returning cash to the unit owners, but I know in some of them it's in there. So what they've done is they've been able to empower the board to make a decision as to what's best for the community. And it's to contribute to the reserves, to contribute it to the operating account, to credit it against the assessments, or to return it. And this, again, they've changed this where this is a decision by the board of directors, but the unit owners upon petition can change the decision of the association. But I think this is going to help in a lot of those questions that come up. Don't forget, still check with your accountants and make sure that under the IRS codes and the IRS revenue rulings, you're still making the proper motion to be able to transfer those funds over if you do have a surplus. Unfortunately, sometimes we don't know until almost 10 months after the close of the year whether or not that exists. Same legislation then talks about what to do with the deficit. You can apply it to next year's budget as well if that happens. One of the other good pieces of legislation, and these are all rolled up into one global bill. Anybody have a declaration that requires mortgagee approval to amend the declaration?
Yes.
Okay, we're changing that.
Yes.
So mortgagee approval will be deemed approved 60 days after sending the request if they don't respond.
Oh, that's great.
So that will help the associations that are handcuffed by the idea of, we know we're never going to get 2/3 or 50% of mortgagee approval because those letters are just going to go into the garbage. So that should be helpful to some communities. There's a couple of changes that really are going to be, again, more on the management side. Any association, and I don't know why this bill was pushed or passed or changed, any association that has 100 or more units must comply with GAAP accounting in, quote, fulfilling their accounting obligations under the Act. So those are basically the financial reporting obligations, but they want you to comply with GAAP accounting. Originally, when the bill was introduced, it was at 1,000. The representative who took over this bill reduced it to 100.
What is GAAP?
What?
What's GAAP?
What's GAAP? Generally accepted accounting principles. Another bill that'll be pretty interesting to the association community is House Bill 2401. That's okay. Yeah, go ahead.
I'm sorry, my staff is coming to get me to another meeting, so I'm very sorry I have to go. Thank you for letting me.
This is my last one. So the last bill that will, there's been a lot written, and there's actually a couple of changes to Section 15 of the Condominium Property Act. I don't know if anyone's been reading the papers about the deconversions of the property or the purchase of a substantial portion of the property. Right now, the way the law reads is if you're an association and 75% of the unit owners want to sell, the other 25% are therefore compelled to sell for fair market value. And there's been some horror stories about that, and there's been some fears about people who may have bought their units in 2008, and now the fair market value of that unit is substantially less. So there's a couple of changes coming to that. One of the changes that's been proposed, there are opponents, so I don't know that this is going to pass, but it has been proposed and it's passed the House, is that if you're over 7 units, that threshold is increased from 75% to 85%. We're trying to shrink the amount of people who would be affected by it. The other portion is relocation costs will have to be paid to those objecting unit owners. The last part is they're trying to include a provision in there that says fair market value or whatever the amount of the debt on the unit is. So somebody's not going to be forced upside down if they owe more on their unit than what they're getting. The last thing is, how many people have heard or been restricted or been kind of heard this concept of, well, you know, the Condominium Property Act says you can't do that because you can only have one class of membership. Anybody ever hear that? Sometimes that's used for everything. Oh, you can't let so-and-so park there because that's creating two classes of membership. You know, you can't have move-in and move-out fees because that's creating two classes of membership. I disagree with a lot of that, but one of the things we've attempted to do in this bill is to clarify that when you're talking about classes of membership, what you're talking about is voting rights. So the word voting has been added in one of the bills to that section, just to make it clear that this isn't designed to restrict the rights for associations to be able to distinguish between maybe an investor owner or a tenant and a unit owner, and they may not all get the exact same parking spaces or storage sheds or things like that. So with that said, those are some of the pieces of legislation that are kicking around. They are making their way. May should be the end of the legislative session on most of these bills. If they don't pass by May, they're probably not going to pass. If they do pass by May, we'll have to see whether or not Governor Rauner wants to sign them. He vetoed 2 pieces of condo legislation in 2015 that had almost unanimous support that he disagreed with. So he does have his own opinion on this legislation. But one of the things I learned working on this legislation, and I was really shocked by it. When the foreclosure legislation was introduced by the realtors and by the banks a couple of years ago, which I thought, and I think most of the people in the condominium association industry thought would really hurt condominium associations and really decrease the amount of recovery in foreclosed properties for condominium associations. That bill made it through the Senate, made it through the House, and it ended up on Governor Quinn's desk. And because of the letters and phone calls and emails, Governor Quinn's office called people in the industry and said, you gotta come in and talk to us because our email servers are getting killed on this. We're getting hundreds of communications on a daily basis from people in the community. And lo and behold, and I'll never forget this, I had the pleasure of being on the phone with Governor Quinn's staff, and I was driving my son to his to college. He was starting his freshman year in college in Bloomington, Indiana, and I'm driving him down there with all of his belongings, and I'm talking on the phone, and they said, yeah, we're changing it. We're going to put in a mandatory veto because we don't like that. We're going to make the banks pay everything instead. I almost drove off the road. I'm not kidding you. That didn't pass with the mandatory veto because it couldn't get the votes, but we stopped what it was, and it was because of people reaching out to the governor's office, reaching out to their representatives, saying, I live in a community association. I live in a condo. I know this is going to affect me. I'm a board member. So again, they're tired of hearing it from me. So the more you folks can communicate with your state reps and your state senators and aldermen, I mean, everybody needs to hear from the people who are actually affected by this. So with that, questions for either one of us? Yes, ma'am.
Well, this is, I am on a condo board, and it is really scary to realize, I'm on a condo board and that's why I'm here, but it's very scary to realize all of the potential legal cost that can be encumbered. And one of the things, and I don't know if Lieberman could do this, because gosh, if I receive an email from Lieberman saying this bill is coming up, this, for example, for the short-term house, the air hub kind of thing, this is coming up in the city of Chicago, contact your alderman, let your alderman know what you think, contact your state senator. I mean, they could do that through the E-Star or through the, push it through the emails. And that would certainly, put that in front of me, and then I could, forward those emails to other people who may not have, know this is coming because they're not on a condo board or they're not, aware of this different condo legislation. I got aware of all of this and the skyline with Don DeBatt, who did an article. So
yeah, it wasn't very flattering either. But I will say this, in terms of, some of this is difficult. I've been personally negotiating this bill. Up until about 10 days ago, I thought there was a significant opportunity to actually draft some legislation that would have addressed some of the needs of the truly hurt homeowners who have bad boards while still protecting a lot of the collection cases and not creating some nonsense. And one of the other things that's in the legislation is it says if you're sending out a demand letter, you can't include attorney's fees as part of it. So anytime somebody's delinquent, you send out a demand letter, I guess the association members, the rest of the membership who have paid their invoices, have paid their assessments, have to pay for the attorney's fee to send out that statutory demand letter. I mean, that's just patently unfair. But I thought we were real close. And lo and behold, at the very last moment, not only did I find out that we weren't even going to talk about any mandatory language, but it was this language, and that was it, and it was full steam ahead. And it quickly went from that on a Friday to a vote on a Tuesday. And sometimes some of that happens legislatively. So politically, we don't want to be saying we're against this when we think we actually are going to have something worked out that we're going to agree on. But I don't see that happening anymore, even though I've been, yet again, promised that we will revisit the idea of a mandatory language. But go ahead.
Your point is a good one, and I'm not sure what Lieberman's policy is with regard to communicating with on-site managers and condo board members, but we as an industry have such a great amount of untapped advocacy potential that for some reason we just don't seem to muster as efficiently as other interest groups do. And I'm actually heartened to hear the story that you told about, Governor Quinn responding to in that one instance. But there's so many more examples where the opposite was true, and when the industry just didn't respond or didn't really get our act together, and we find out that after the fact our rights are diluted and our interests are trampled upon, and it happens time and time again. I'll share with you a story. It goes back to my time as a condo board member. I was the president of a building that was constructed prior to 1975, didn't have sprinklers. During that whole debate about life safety evaluations, we kept having to beat back mandatory sprinkler legislation, and one alderman in particular was such a strong advocate for the sprinkler industry, and I respect him, but we were fighting back and forth, and shortly after I got elected, I went to see him with an ordinance that I had drafted. It was basically his ordinance imposing mandatory sprinkler retrofits on all pre-1975 buildings with one very, very minor change. I made it apply to all residences in the city. That was it. And he took a look at it and he said, "This is a horrible idea." And I said, "But it's your idea. All I did was apply it citywide as opposed to just, residential high-rise communities. How can it be a good idea for condo buildings and a horrible idea for the guy who lives in the bungalow in Mount Greenwood?" I don't understand that mentality. Well, he really didn't have an answer for that. But it illustrates the mindset that, home ownership is sacred, right, among legislators. But somehow, people who own a condo in a community association aren't really homeowners. What nonsense. I don't know how you arrive at that logic, but time and time again, we see evidence that is the thinking behind it. And the response from our industry, we have the potential to stop things like this. Before Alderman Smith left, I kind of whispered in her ear, I'm going to Springfield when the Senate Judiciary hearing is held, and I offered her a ride, and she's going to come schedule permitting too. We really need to sound the alarm bells on this one. House Bill 3755 would be not only a destructive measure, not only would it empower the problem residents that we all know about, but it would be very costly because we're going to have to pay those insurance premiums, we're going to have to pay those legal fees. This is a terrible idea, and the only way we're going to stop it is to mobilize the troops once again and get the word out. We really need to do that. I'm not going to take this for granted that the governor would veto it if it lands on his desk. The governor is not someone that I have a good track record with predicting what he is or is not going to do. I'd rather not give him the option. Let's stop this in the Senate. So to our friends at Lieberman and all the other management companies, we need to really put the word out to the condo associations that it's time to start making some phone calls and emails.
Thank you. For the benefit of the audience, when this important legislation does come up and it threatens condominium associations and owners in any way, we're extremely active in getting the word out. As soon as a lot of the attorneys have been kind enough to draft letters for us to send to board members and then out to owners, and when Governor Quinn vetoed that bill, we were extremely active in it, and all of the management companies, I think, do a good job at that. One of the main reasons we wanted to have this particular panel this evening was so that folks can, see you and you become become more human, and they understand that you really do care, and when you ask for something, you'll help if they respond in return. So you should expect communication from us as these things develop, and we're happy to do it.
And one of the lucky things, the co-chair of the committee that I'm on is a Lieberman employee. So Charlie does a great job of being able to communicate that as well, because he's getting it when I'm getting it. Sometimes we're getting it quickly, but some of this is happening at light speed sometimes.
Okay, we have a few more questions.
My name is Rich Diltz, I'm with the Catawba Gardens condominiums. I just wanted to add on to a comment that you guys just made. You know, when you guys are talking about legislative that we need to get behind and you need our support, I would encourage you to work with Lieberman, because I think one of the reasons why you're not seeing the constituency really rise up is you've got people rotating in and out of these roles, right? I've only been a board president for a couple of years, right? What do I really know? You guys have said things tonight that I'm like, I'm sitting here going, what's that mean? And I'm still learning. So as those things come up, you know, tap into us, right? Educate us, tell us what we need to know, then we can support you. Because if there's something that I don't know about, or if I don't have any awareness around, or I don't have any education about, I'm not gonna stand up and speak about it if I don't know about it, right? So if you help educate us, and you partner with Lieberman, and Lieberman kind of sends that out to us and said, this is the repercussion of what this is, then we can get behind it and support it. Yeah. So that's just an add-on comment to that. But my question is completely unrelated to what we were talking about. There were 6 things tonight that you were talking about now that's a little more flexibility in talking about in executive sessions. I caught 5 of them: litigation, consulting with your attorney, rules and reg violations, unpaid assessments, appointment of employees, and
Contractor.
Oh, yeah.
6 point, the 6th point.
Let me do 2 things, okay? Just so anybody can find it later. It is section 18A9 of the Illinois Condominium Property Act. First one is discuss litigation. Pretty simple. The second one is to discuss the appointment, employment, engagement, or dismissal of an employee, independent contractor, agent, or other provider of goods and services. The third one is to interview a potential employee, independent contractor, agent, or provider of goods and services.
that's what it is.
Okay.
Thank you.
I usually don't need a mic. I don't have one of those inside voices. An Airbnb question. I have actually 2 questions, one on Airbnb, one on the trash pickup. Airbnb, our building, 201 East Chestnut, we're registered that we don't allow that, so we're good. But why haven't we gone after the industry from a tax perspective? I mean, they're nothing more than a hotel room, and hotels pay a huge financial tax burden to the city of Chicago through entertainment tax, room tax, food. Why can't we go after Airbnbs in the same fashion?
Yeah, that's an excellent point. What we did with the ordinance that did pass into law, we did impose an additional fee that the city is collecting. The money goes into a dedicated fund, which is used by the Department of Human Services to combat homelessness. So that was kind of a little PR twist that we thought we would throw back at the industry, you know, that we're going to use this money to help solve a social problem. What we had in there originally, in addition to that was taken out, which, you know, I fought against losing it, we lost that battle, was an additional fee to help us fund enforcement, to hire more investigators and field staff in the Department of Business and Community Affairs to get out there and, you know, respond to calls, especially when we get 311 calls on a Sunday where something's ongoing. Oh yeah, we'll get to that first thing Monday morning. You know, by that time the violation is gone. So we need additional staff, and that was taken out of the ordinance. We are going to try again in October during budget hearings, we have an amendment already prepared because we know it's not going to be in the mayor's budget. We're going to have to fight for this once again to put additional funding in there to hire more field investigators and help us enforce this. Because really, what good is an ordinance if it's unenforceable? And the word gets out pretty quickly among the industry that, hey, you can kind of get away with violating this. Nobody's really minding the store. I mean, even if your neighbors complain, you know, the staff is so overwhelmed, they just can't keep up with the volume of complaints. So we absolutely have to find a way to pay for additional enforcement measures. And it seems to me that there's no better source for that revenue than to go right to the people who are using these services.
Okay. My second question, and thank you for indulging two questions. The pickup of trash in the city of Chicago, condominium buildings, and this could be my misunderstanding, but condominium buildings seem to be taking a hit on this. We're homeowners, we pay property taxes, real estate taxes, but yet now we're gonna have to be paying to pick up our trash, even though that is something that homeowners get in lesser high-rise buildings, like 3-story buildings, or single family. Why are condominiums, at least in my understanding, why are we being penalized as homeowners, residents of Chicago, good citizens, why are we being penalized? Why are our buildings being penalized?
Yeah, and your point is valid, and it's even worse than that when you think about it. What it costs us as a city to send one of those blue city-owned garbage trucks to spend an 8-hour shift collecting trash from single-family homes, you know, in Mount Greenwood, or not to pick on them, let me think of another one, Jefferson Park, versus what it costs a private scavenger service to empty the container that serves 400 homes in a high-rise. They can do that in 10 minutes as opposed to the 8 hours that it takes union crews with 2 people on a truck to drive through a neighborhood and collect trash from 400 homeowners. So not only are we more efficient, much more efficient in our waste disposal, but we do pay twice. We have to pay the private scavenger service and you pay your property taxes, so you can subsidize the single-family home neighborhoods to have this city service provided free. I don't know how you defend it. I really don't. Although, and not to throw the mayor under the bus here, but I have to say, when we argued with this during the budget that eliminated the refuse rebate, he just flat out said, I gotta get money from somewhere, and we're gonna go after the high-rise community on this one. Again, going back to my point with the sprinkler system, there's just this idea that we're easy targets, and we can be rolled over, and we can be disrespected, and we can have our rights trampled on, and we can be double taxed. I don't know how we got the reputation for being such easy targets, but unfortunately we do, and we have to fight back for it. I think that was a terrible decision. You know, I know there was a lot of phone calls made, and the management companies and other condo boards, you know, said, hey, we're going to lose this refuse rebate. It was being scaled back. It was sort of a battle of attrition. You could see it coming. It got smaller every year, so you could really see the direction that was heading. And now it's gone completely. That's not to say we've given up on that. And even though this mayor remains adamant for his own reasons that he didn't want to have to to dip into a revenue source to continue funding the rebates. As a representative of a ward that has a high percentage of community associations, me and the other aldermen who are in that situation are going to continue making the argument that it's not fair. And actually there was litigation on this years ago. I think it was probably 20 or 30 years ago. There was a court case on it. And it may require, once again, it may require going back to court to point out an inherent injustice in the way refuse collections paid for in the city of Chicago.
And most other municipalities as well. That's a pretty standard approach when it comes to condominium associations across the northern part of Illinois. That most of the condominium associations are having private refuse pickup where homeowners are receiving it. Now, in different communities, they might have to pay for it, but in a lot of communities, it is with the property taxes.
On House Bill 3755, is that the one that came out of the Spanish courts case?
Pretty much, that's where it started, yeah.
Okay. Who's the Senate sponsor on that, and are they a downtown or a lakefront legislator?
I'm not sure who the Senate sponsor is. It was just voted in, it just moved over to the Senate this week. So I haven't really checked who the Senate sponsor is at this point in time. It was Representative Drury, but he was one of, I think, a dozen, maybe even 15 sponsors by the time the bill left the House.
Okay, we have time for one more question. Does anybody have anything else they'd like to ask?
There's one there.
Alderman, are they as far behind in reimbursing your north side towers, condos as they are on the south side? How many years behind are they? We haven't been paid since 2010 for our
On the refuse?
reimbursement.
Yeah, we're 5 years behind.
About 5?
It's ridiculous.
Okay, thank you so much to our panel, to Patrick and our Alderman. We certainly appreciate the information and the call to action, and we will send out information on these bills and the 6 points. We thank all of the board members for giving up your time this evening and participating in this event. We appreciate partnering with you in these types of activities, and this is the time in the evening where John typically tells you that you can all just double your salaries for being board members. Again, thank you very much for attending.